Seeing some familiar faces in class today. Also a face that I haven't seen for a while. Welcome. People, I am very, very disappointed in this group of students, to be perfectly honest. And right now I'm shouting at the wrong people. Because you are actually...
Yeah,
Yes, Miss Johannes?
I just want to say my apology because I had been away outside of the country with the Olympic solidarity study.
Um, yes, thank you. I appreciate that. I also
Yeah.
realize um, that not everybody can attend every class, which is why I record the classes while I do upload them on YouTube. I'm a little bit behind with the uploading. I'll catch up in the course of the weekend. So I don't expect 100% class attendance because life happens. But the general average class attendance is 3 students out of a group of 20. That is not okay. I've started looking, I haven't actually started marking formally, but I've looked at some of the assignments. They are shocking. Doesn't matter how many times I said, do your own work. Use only the study guide. What do? You Google, you AI. And you think I'm stupid that I'm not going to pick it up. Not the Saturday after is your face-to-face test. Um, Face-to-face test is, let me just check quickly, 45%. 45% of your semester mark is your face-to-face test. There's no makeup test. You've got one chance to write. And I'm not giving additional opportunities and reopening quizzes and please, ma'am, I missed it, whatever. Anyway, we're moving on to labor law. We've now finished with the law of contracts. And then last week we looked at agency. Agency is, in fact, part of the law of contracts because, as we learned, the concept of agency, representing somebody else, arises from a contract between the principal and the agent. Just want to share my screen quickly. So now we are moving on to labor law. Labor law important in sport, labor law important in your everyday life. It doesn't matter at the end of the day whether you make a career as a professional sports person, uh, a career as uh, in sports management, or something totally different. You go and work as an accountant, something like that. Labor law, integral to your future life. Um, I actually have some PowerPoints that I have prepared. They are PowerPoint slides are on e-learning. They have been uploaded there. Okay, so starting off then with Unit 10. Unit 10, title for Unit 10 is Employer-Employee Relationships. So, labor law, what is labor law? Learning outcomes at the beginning of each unit. Make sure you go after you've worked through the unit, that you go back to the learning outcomes, and actually that you are able to answer those questions, that you have actually achieved the requisite outcomes. So what is labor law? What are we talking about? Labor law can be defined loosely as the rules. The rules, remember, we've learned what law is. Laws are rules and regulations. Labor law, the rules regulating relationships between employers, employees, employers' organizations, trade unions, and the state. It's important to understand that although labor law is a private law relationship, the relationship between the employer and the employee, the state also plays a large role. We have a Ministry of Labor that oversees labor relations in the country. So labor law has two sources. It arises from the law of contract. Your labor relation, your employer-employee relationship is based on a contract. It is always based on a contract. So all your normal requirements for the law of contract also apply to labor law. And please don't get me wrong, don't get confused now. If I say it's always based on a contract, that does not mean it has to be a written contract. A written contract is not a requirement for an employer-employee relationship. But apart from the law of contract that regulates the relationship between the employer and the employee, we also have labor law, the Labor Act of 2007, which regulates what can and what cannot be in this contract by way of, for example, your basic conditions of employment. But looking then firstly at the contractual aspect. No, before we get there, just a bit more background. We get two types of labor law. There's individual labor law, which is regarding the relationship between the employer and the employee. And then we get collective labor law, where one of these parties is a group. So collective labor law, that is then the relationships between employers and trade unions, employees and employers associations, etc., etc. Individual labor law, one employer, one employee. We do in the 4 units in the study guide that relate to labor law, we do primarily individual labor law, but there is a little part of the syllabus which is also on, or where we also look at some aspects of collective labor law. For example, the requirements before a group of employees may take industrial action. So back then to the contractual aspect, first thing we need to look at is we get 2 different types of contracts that involve work. We can distinguish between employees and independent contractors. How do we distinguish between employees and independent contractors? That is discussed in the study guide. In terms of the Labor Act, an employee is an individual who works for another person, whereas an independent contractor is a self-employed individual who works or renders a service to another person or an individual. An example, for example, I am an employee. I work for NUST. If NUST wants to paint the outside walls of campus and they appoint a painting company to come and paint these walls, in common English, in uh, in speech, the contractor might say, "Oh, I got the job to paint the walls." You saying "I got the job" doesn't make him an employee. He continues to work for himself. He's a self-employed individual who is appointed to do a particular task. Why is it, how do we distinguish between, how do we figure out whether we are dealing with an employee or with a contract of service? There are a number of pointers that you can use as a guideline. Is it salaried? The manner of work, is your work subject to the control of another person? Your hours of work, are they subject to control of another person? You could look at benefits. Are there benefits like pension, medical aid, that type of thing? So there are a lot of pointers that are used to distinguish between whether the relationship is that of employer and employee or that of an independent contractor. Now, why is it important to distinguish between whether somebody is an employee or um, an independent contractor? This question was in your assignment. Somehow the AI you used decided to rather tell me what the differences are. That's not what I asked. I asked, why is it important to distinguish? But your AI generators misunderstood my question. Why is it important to distinguish? Because the Labor Act only applies to employees. It does not apply to independent contractors. So if you are an independent contractor, you're painting the walls at NUST, and you have a certain time limit to finish, and because you're not going to be finished in time, you end up working till 6, 7 o'clock, 8 o'clock in the evening. You cannot claim overtime from NUST. You get sick, can't get sick, you're not eligible for sick leave. It's at your own loss if you leave missing time. And then vicarious liability is only applicable in the event that there is an employer-employee relationship. Going to explain what vicarious liability is towards the end of this lecture. So those are the two reasons why it's important to distinguish between whether the relationship is that of an employer-employee or whether it is a relationship of an independent contractor. Okay, so we've looked at that slide. In terms of the Labor Act, the presumption is that the person is an employee rather than an independent contractor, but a presumption doesn't mean it's a fact. You can always bring evidence to the contrary. Those distinguishing characteristics, I've already spoken about them. Okay, that's supposed there, sorry. Okay, there's a little table for you to distinguish the distinction between employees and independent contractors. This is important for your test and your exam, by the way. Okay, so in this course, we are dealing with employees, not independent contractors. Employer-employee relationship arises from a contract. So all the requirements for a valid contract have to be present. If you can't remember those, go and revise them. There must be a valid offer coupled with a valid acceptance. But it does not have to be in writing. Contract of employment comes into existence as soon as one person has agreed to work for the other in return for remuneration. Then you have a contract. Lots of people don't know this, and it could happen to you. Maybe it has happened to you that you've been working for somebody and then eventually you want your money, it's end of the month, you must pay, want to be paid, or you want your overtime and whatever, and they say, but you don't have a contract. Off you go, you never signed. You never had a contract. That is nonsense. You do not need to sign a contract to become an employee. And the moment you become an employee, the Labour Act is applicable to you. The minimum conditions of employment are applicable to you. Don't let anybody else talk nonsense into your ears that that is not the case. Okay. And then within the realm of sport, it becomes a little bit vague sometimes. The presumption is that the Labour Act also applies to professional sports persons, but it's a vague, and I believe it was pointed out to me, well, not pointed out, there was a question from a student while he was preparing his assignment one, the question that related to the professional football players. Are they really employees or not? In this particular, in every instance, when it comes to sport, context of sport, you will have to look at the facts of the particular relationship. Can you say that this particular sports person is an employee of a particular club, or are they more of an independent contractor? They maybe just get a stipend or an appearance fee, or maybe they're not even remunerated at all. The bottom line is you will have to look at each individual situation to determine what is the precise relationship. Of course, also the basic conditions of employment will not apply to professional sports persons, copy and paste. If basic conditions of employment, for example, payment of overtime, payment of work on Sundays and public holidays. But on the other hand, if you are a professional sports person and you have a match on Sunday, I personally don't think you'll be able to then claim overtime for playing a match on a Sunday. So that will depend. What we talk learning in this course, we're looking at your traditional, call it traditional standard employer-employee relations, not necessarily the employer-employee relations as they relate to sport. Those are a little bit too vague. You'll have to, if there's a situation concerning a professional sports person, look at the individual circumstances. Any questions so far? Okay, then the next part of Unit 10 concerns the basic conditions of employment. It's also contained in Unit 10. I have a pre-recorded lecture on basic conditions of employment, so I'm not going to lecture on that today. That pre-recorded lecture is on e-learning. Also, you do not have to memorize. You do not have to memorize the basic conditions of employment. The section of the Labour Act which refers to the basic conditions of employment is on e-learning. You can download it from there. Please do, and please print it, because you will need it for test 1, and you can bring it into the venue. I do not believe in unnecessary memorization. I don't believe in memorizing things that you can look up quick. You've all got smartphones. If somebody asks you, how many days compassionate leave do I get every year? It's going to take you 3 minutes to quickly Google it. Download the Labour Act, look it up. So you don't have to memorize these details. You need to know how to apply them. I will give you a case study regarding somebody's employment. You have to compare what is expected of this person. Is it in accordance with the basic conditions of employment, yes or no? By comparing with the basic conditions, not having memorized the basic conditions. So for test 1, be warned, you may bring a hard copy of the basic conditions of employment into the test venue. If you need it in the exam, I will attach it as an annexure. Any questions about that? Okay, so let's move on then quickly to the next unit. Unit 11 deals with the rights and duties of employers and employees. Let me just get my slideshow. Okay, so once you have a contract of employment, and I'm going to remind you again, contract of employment arises the moment one person agrees to work for another person for remuneration. Then you have a contract of employment, and from that moment, these rights and duties that I'm going to be looking at briefly now in the rest of this class are applicable. These are general rights and duties. These are common law rights and duties. Of course, for every particular situation, there will be specific rights and specific duties. If you get appointed as secretary, then you will have your duties as secretary. That's not what I'm discussing now. That will depend from the particular situation, whether what you have been appointed for, what is stated in your contract of employment, what is stated in your job description, etc., etc. What I'm looking at in this slideshow is the general common law duties, duties that arise at common law. Because of common law, the moment there is a contract of employment, you also cannot contract out of them. They will always apply. Your learning outcomes, remember to check your learning outcomes. So the duties of the employer, essentially to pay remuneration, the provision of work, safe working conditions, accommodation, provision of accommodation and transportation upon termination. Before you start memorizing those, let me discuss them first. So, payment of remuneration. You need to know the difference, firstly, between remuneration and basic wage. Difference between remuneration and basic wage is explained on page 50 of the study notes. Remuneration, that's everything. Basic wage, just the part let's read the definition. That part of an employee's remuneration in money, including cash equivalent of payment in kind, but excluding allowances, blah, 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 blah. So your basic wage is that which you get without all the other benefits. Remuneration is everything. Payment in kind, so you get food and stuff instead of getting cash, only if that is only in terms of agreement with a specific employee or in terms of a collective agreement, and up to a maximum of 1/3 of the employee's basic wage. So you cannot refuse to pay somebody and say, no, I'll give you food. Maximum 1/3 of their wage may be payment in kind. So what arises? What would the situation be if no specific remuneration has been agreed upon? That can give rise to one or two situations. Firstly, that there is no of employment. Remember, when does a contract of employment arise? When you agree to work for somebody in exchange for payment of remuneration. So if you didn't decide on or agree on a remuneration, it could be that there is no contract of employment, or alternatively, that the employer must pay you a reasonable wage for that particular industry. The Labour Act of 2007 does not prescribe a minimum wage. The Labour Act does not say this is, you must pay your employees at least this. It does, however, provide for collective agreements in specific industries. that can determine a minimum wage for that particular industry, the security industry, etc., etc. But the Labour Act itself does not prescribe minimum wage. Also, very important common law principle: no work, no pay. So, if, for example, you went on strike and you didn't work for a week before the issue was resolved, the employer has the right to deduct that week's wage for payment. Actually, just in real life, if I can interrupt myself, quite sad sometimes that many trade unions, when they are organizing strikes, do not inform the employees of the no work, no pay rule. And they think they're very excited to be involved in the strike. Oh, we're going to strike. And then at the end of the month, their salary check that they get is suddenly a lot smaller than they expected it to be. That happened at NUST a couple of years ago, when the first time that the NUST admin workers went on strike. Some of them were caught by surprise at the end of that month when they ended up getting paid a lot less because the institution deducted the days that they were on strike. That is legal. We may do that. Not saying it's right, but it's legal. Okay, then provision of work. Question arises, must the employer provide the employee with actual work to do? At common law, the answer is no. So as long as they pay you, they don't have to actually give you jobs to do. You can come in and sit there on your backside and do nothing the whole day, as long as they pay you. They must also, the other flip side of the coin is they must allow you to do your work. They can't lock you out. They can't ban you from the premises, but they don't have to provide you with the work. There are certain exceptions to this, instances where the employee works for commission. So by not providing them with the opportunity to do the work, to earn the commission, that they're getting financially disadvantaged. If your job is related to publicity, if your earning capacity is influenced by publicity that you get from working, if the failure to provide you with work degrades your status, or if you require the work in order to maintain or develop skills. Those instances, there's a common law obligation to provide you with skill, with work. Otherwise, if doesn't fall in one of those categories, employer doesn't actually have to give you work to do as long as they pay you your agreed remuneration. Question once again with regard to your professional sports person. Can open up for, make space or make room for an interesting discussion. If you have a specific contract with a specific club, you can argue that it's a situation where your earning capacity gets influenced by publicity. You have to pay to build up your name, to get better known. Not playing degrades your status. So you can argue that it falls in those categories, that they must give you work. But on the other hand, you can ask, must give you work, does that mean they have to put you in the team? Or can they bench you if you're not performing up to the required standard? Must they make you starting lineup or not? Interesting questions. No specific correct answer there. Would be interested to hear your opinions. Okay, safe working conditions. I'm going to go over the rest of these duties quite quickly. The employer must provide safe working conditions to the employees. If they don't provide safe working conditions, the employee feels unsafe, they have the right to inform the employer and leave the premises until such a time as the necessary steps have been taken. Provision of accommodation. Now, the fact that I have provision of accommodation here